I love these questions, you guys. It's so many questions. I wish we had time for them. But again, reach out to them, reach out to speakers, reach out to us, we'll connect you. Speaking of surveys and getting feedback, please give us feedback after this, because we are a brand too. We want to know if this works. You guys are our audience. Be honest. Please tell them Ace sucked. He was a terrible speaker. I was bored to death or something like that. I don't care. Be honest. Throw it out so we know how to make these better. So with that, I'm going to go to our next speaker. The next speaker is Varand Gourjian. He is the founding partner of Gourjian Law Group. He is basically, he's worked with, I want to say, from Fortune 500 companies to small investments and small investors, entrepreneurs and startups. He's very knowledgeable. I think he's worked in, he represents like developers, real estate, attorneys, investors, etc. So with that, I hope Varand is here. Can we welcome, please, Varand Gourjian.
All right, thank you guys. Welcome. What I'm going to talk to you guys today about is something I just titled Addressing the Tough Questions. And what I want to cover is something that I've realized over the years is extremely important for entrepreneurs who are starting their companies to think about. And it's very often overlooked. It's overlooked due to the excitement of whatever it is you're ready to jump into. And it's overlooked because when you've come up with your business idea, when you've found a partner that you're going to jump into bed with in developing this business, all you're thinking about is the money you're going to make, the name of the business, the brand, the logo. Everything is positive, everything is exciting. You've saved up a few $1,000s to spend on an attorney, and you come to an attorney like me or Ara, and obviously we start advising you on the corporate structure, the tax implications that either entity may have, and you already have answers as to what the corporation is going to be called, and if you're there with a friend, or a partner, it's going to be 50-50, or how all the money, all the wealth down the line is going to be split, and that's where your information ends, and that's where this talk begins, addressing the tough questions. So that's what I want to kind of go over with you, because I realized how important it is to, at some point before you begin this journey, stop yourself and ask yourself these tough questions. And the context within which I'm going to talk about is not the businesses that you start alone as the sole owner of a company, and not companies that have progressed to where they're going public, but it's that other realm in between the two. It's businesses that you have a partner with. And by partner, I don't mean the legal entity of a partnership, but I'm talking as a co-owner of stock in a company or membership interests in an LLC. Generally what happens, right? Two people come to me, whether they're friends from college that have thought of an idea to do together, or they're two successful businessmen or women who have their own ventures, and they're going to do something together for the first time. And they'll come and say, all right, we're going to do this 50-50, and let's take some examples. One guy's going to put up the money, the other guy's going to run the thing. It sounds great initially because the guy who's going to run the thing and whose idea this is says, look, I couldn't have done it without him. He has all the money. And the guy who has the money says, I really believe in him. I've known him my whole life, and if there's anyone who can do it, it's him. So I want him to have 50% of it, I'll put all the money. The other guy says, I couldn't have done it without the money, so I want him to have 50% because otherwise I'd have nothing. And they're all excited, and they're ready to give me the information and run out and get some paperwork and get started. And that's when the come to Jesus talk happens. That's when the tough questions happen. And that's where the fun ends, and I say, all right, let's all sit back for a second. We're going to talk about a couple of things. First of all, one thing I want everyone in this room to realize, when you're divvying up stock in a company or an LLC's membership interest, right? When you're taking ownership interests in companies, these are things, these are assets. These are not just, oh, I'm going to get half the profits or I get to deduct half the losses, right? You own something when you own stock in a company, shares in a company, as does your partner. If things don't go well, unless you've thought about it ahead of time, unless you've planned for it ahead of time, you can't say, hey, give that back, Okay, it's something they own. Similarly, if you haven't planned in advance, you can't tell them, no, 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 don't do that with your stock. Don't sell your stock to that guy. I don't like him. You know, he wasn't a part of this equation. So you have to realize that walking in and saying 50-50, half the stock to him, half the stock to me, let's get started, has some serious implications. So first and foremost, voting, right? Owning an interest in company usually is tied to being able to vote those interests. Okay? And one thing I want you to realize in doing things with co-owners of companies, other shareholders in your company, especially if it's equal shares, is that at some point, if you haven't thought about the ramifications, good and bad, this can become a problem. And the most simple example is young, excited people or sophisticated, excited people. When it's all excitement in that conference room, they say, all right, but we'll decide together. You know, I won't make any decision on my own. It's going to be unanimous. We'll make everything unanimous, okay? We'll both agree on everything. Again, that's the positive and excited view of it. What they don't realize is when you require a unanimous vote for something, one vote can veto that plan. That one vote can veto that decision, because it otherwise requires unanimous consent to go forward with that decision. And when you put it that way, you know, in the negative, it gives reason for them to stop for a second, and it gives them pause. So it's something to think about. So the next issue is, moving past voting rights, is what I brought up earlier, the asset of the shares themselves. Unless, and we will talk about how to address some of these things and what options there are, but you have to realize something, that in that excitement, in the partner you've chosen in your business venture, it's a very personal decision. It's one thought through based on your specific abilities, skill set, and whatnot. And by taking an ownership interest in a company together, in a new venture together, what you're in fact doing is when you give each other shares in that company together, and without addressing problems, you're giving them something that they can do anything they want with. If you have not addressed this issue, if you haven't thought through this issue, the truth of the matter is, for example, they can voluntarily transfer their shares. They can sell their shares. The company starts growing. It does better. One of the two get bored. They don't want to be your partner anymore. They don't want to work with you anymore. You don't get to control what the other person does with, in this example, half your company. And the voting rights that go with it, the profit distributions that go with it. So if you haven't thought that scenario through, made decisions on how you're going to address that, you need to realize that that can become a real problem down the line. Another problem, a more difficult problem, because let's just assume that friend that you knew who's a successful businessman and you trust and you've seen how well he does, would never sell his shares without asking you. What about if he dies? He didn't make that decision. He's exactly the partner you believed him to be. But things happen. People die. What about if he gets incapacitated? Okay? What about if he turns into a drug addict? Or what if he gets just bored or lazy and doesn't want to pull his share? Okay? This is something you have to think about. Because once those shares are his, those shares are his. It's not like a salary, for example. If all you've agreed upon is paying someone a salary for doing certain tasks or chores or job description, right? If they don't perform those things, they don't get paid the salary. But when you walked in on that first day saying, we're going to be 50-50, and the attorney issues stock certificates, that's that. So, what happens when, for example, your partner goes through a divorce and he's been an ideal partner until that day and continues to be, and the judge in the dissolution proceeding awards his spouse the shares of the company. Show up to work the next day and you have a new partner. Alrighty then. I don't know what the spouse can do or can't do. I don't know if you want the spouse as your partner, but it's going to be a very, very traumatic blow to the company, I assume, in many cases. What else? Another thing that I've seen very, very often. Let's rewind back to that first example I gave of the one friend or business partner putting up the money and the other one running the show. It's initially, when you talk about it, you know, especially if you're the guy with the idea, you're the guy with the plan, the guy who's going to make it all happen, and you know you just can't do it other than without finding the money. And you found the money. I mean, there's nothing more exciting than that. A guy believes in you, trusts in you, and says, I'm going to put up the $100,000. I'm going to put up the $1 million. I trust you. I want you to have half the profits. And there's no better feeling, I would say, for that guy who comes in and gets started. And he does really well, just like the investor partner thought he would. He does extremely well because he works morning, noon, and night, and beyond midnight. And he does it again and again, 1 year, 2 years, splitting profits, 50-50, 5 years, 10 years. He's working around the clock. And what kicks in at some point after 20 years of sleepless nights? Suicide. No, hopefully not. But before he gets there, he starts, and this happens all the time, he or she starts resenting that friend for taking half of all those millions. It's like, wait, 12 years ago, that guy put in 100 grand. He was a millionaire. That 100 grand was nothing to him. And I work day and night, and you know, I don't see my family, and I made this company be what it is today. It's spitting out millions and millions, and half of it's going to him. He made $10 million on his first, that 100,000. He didn't even remember that 100,000 he gave me. Why should this keep going on? But you know what? He owns half the company. And all of this could have been prevented if they addressed these tough questions in advance. Anyone in my shoes, in our shoes, knows on our computers we have voting agreements, shareholder agreements, buy-sell agreements. They're there. And these are the type of simple agreements that can address all of these scenarios. But the purpose of this talk is to just remind everyone in this room who anticipates getting into any kind of partnership to stop and ask yourself these tough questions. It's not fun. It's a Debbie Downer issue, right? Because you're talking about your partner who's going to be putting up this money, you resenting him. You're talking about one of you getting divorced, dying, becoming a drug addict, incapacitated, not pulling your weight, right? No one wants to talk about that. They came to me to give me some money, to get some papers, to go open a bank account and get their website up and make money. But I can tell you guys, this only becomes a non-issue if your business just quickly fails. Because it doesn't matter, right? For the most part. But to the extent you are getting into a business venture with someone else and you've thought of all the positives, the upsides, all the great things that are going to happen, and all the love and affection and respect you have for each other, but have not thought through all the disappointing, frustrating, sad scenarios I just threw out at you, you are setting yourself up for problems. So, I said that I talked briefly about how some of these things work. I'm not going to get into the mechanics or the specifics of it, but I will give you some examples. The most practical one being that last document I mentioned, which is a buy-sell agreement. And it works quite simply. And I'll give some examples. It says, for example, that if I and my partner own 50% each in our company, what we do is we come together every few years, however often you just write in that document, and we say, hey, what do we think our company is worth? This year we decide it's worth $1 million. And we come to an understanding that if, God forbid, either one of us die, the other person who remains alive will cut a check for $500,000 to the remaining spouse of the decedent and take his or her 50% of the company for himself. So the surviving owner gets 100% of the company, full control of the company, and the spouse of the partner who died gets compensated for it. And it can even be simpler than that. You can say, okay, well, if I'm not going to have half the value of the company, there's keyman life insurance policies. There's insurance policies that even exist for scenarios like this that will pay for that. We can agree on in the buy-sell agreement that, okay, if that happens, I can pay out your spouse over a certain amount of time. And there's already formed promissory notes attached to it where the percentage of the interest rate and everything is agreed to. So that's one example of it. In those buy-sell agreements, there's also provisions about incapacity. You know, if one of the partners does become a drug addict or does not carry their weight in doing what they need to do, there's provisions about if they get divorced and, you know, if as part of the divorce nothing changes as far as the ownership of the company, it goes on. But it's interesting that in the divorce provisions, it also says, for example, if I'm the one getting divorced and a certain percentage is going to go to my spouse, I have the first right to buy it from my spouse and stay involved in my business. And if I don't, then the other partner gets to buy the shares. And that brings me to another interesting thing. Because, like I said, shares in a company, interest in an LLC are assets. Because we are a community property state also, spouses sign these buy-sell agreements also to be bound by it. To be aware of it, that upon the death of their spouse, that this asset, there has already been an agreement for the asset to be bought out or transferred or whatnot, A, to be made aware of it, and B, to consent to the terms of it, because it will affect the spouse in that scenario, for example. So, in short, this is the, addressing tough questions scenarios that I wanted to get all of you guys to think about. Yeah, it's not fun. It's not fun in that excitement, but it's much less fun after the companies become very, very successful and you're facing a dilemma because these things hadn't been talked about and thought through. And one other suggestion, don't leave this discussion to the attorney to initiate when you come to him ready to start the company. Try to do it with the partner beforehand. It's not pleasant, but if you can see eye to eye in these difficult scenarios as you pose to each other, it gives you that much more confidence in the partner you've chosen for your business. So that's it for the presentation. If you have any questions.
Can you put a first right of refusal?
Yes, absolutely. In fact, that was one of my notes, and I forgot to mention that. So, good question. For those who didn't hear or don't know what that is, he asked if you can put in a first right of refusal. I should have talked about that. I missed that topic. What that says is, if one of the owners wants to actually voluntarily sell his share in the company, what it says is, okay, well, I can't hold you back from doing that, right? There's a law against alienation. You can't force someone not to sell something they own. But you can, by agreement, say, if you're going to sell it, let's say you get an offer for $500,000, I get to match that, and I get to take the other half of my company. So it's a right that the partner will have. It's called the first right of refusal to buy those shares. Very good question, and I'm glad you brought it up. I forgot to cover it. Yes?
If you have your company shares in a family trust and the trust outlines how it's supposed to be handled after you die, does one supersede the other or has nothing to do with it?
Very good question. In a lot of my buy-sells, the actual entity that's a party to the buy-sell is a family trust because it's the owner of the shares. So if you don't have a buy-sell in place, then your shares will be governed by whatever your trust says. But to the extent the trust enters into the buy-sell, it's the buy-sell that will govern, because the trust will be a party to it. To the extent there's conflicting things, I'll let the courts decide. But yes, it's very common that because individuals who have estate planning done put all their assets into their trust, the shares of a company would be in that trust also. So the signatory to the buy-sell would be the trust who holds the shares. Back to you.
Indemnifications, would you leave it out?
Well, indemnifications are a different thing, but, and they don't pertain to these issues that arise, but indemnifications usually will go into most agreements. And because in cases of a buy-sell, issues may arise, specifically in the case of death with other spouses, then yeah, you always presume to have indemnifications in there also. Similarly, there's a lot of other protective language. For example, to protect bona fide purchasers of shares, we have restriction language that's reflected in the buy-sell that must be put on stock certificates, because if you sell your shares to someone else and they don't know that there's any restrictions or that you're a party to a buy-sell, they may think they're buying stock free and clear of any liens, claims, encumbrances, issues. But because the buy-sell requires language on your stock certificate, it would notify a third party of the fact that it's subject to the terms of a buy-sell. That's it. Thank you guys very much.